So this is a question about discoverable information with respect to meetings. So let's say your company gets a notice from the FDA, it may be about a recall or something, and everybody gathers together on a video, and somebody's real smart and wants to use one of these transcribing software programs. And the next thing you know, you have a verbatim minutes of your meeting, and somebody during the meeting said something they might not want to have publicized. So the discoverability of these meetings are video meetings where there's automated transcriptions. I'd like to have you comment about that.
Certainly comment about that. I had a case at the AG's office where one of our smoking gun pieces of evidence was of one of the sales team recording a meeting. And in the meeting, the company was training the sales team on how to twist the words and essentially exaggerate what the product could do, and said, make sure you do not leave any of these handouts at the hospitals or clinic. We don't want any evidence. And all of this was recorded, and it was subsequently produced in discovery. And it was something that I used in a deposition, and it's not privileged unless it's privileged information, meaning it's protected because someone is talking to their attorney or husband and wife. It didn't meet any of the exceptions. So it was 100% admissible, and it was very damaging for the company. So you really do, I mean, you don't know if even right now someone's recording, right, but you do want to be careful. Maybe make a note before a meeting and say, hey, please no recording. And, just take the proper precautions. First of all, don't do anything illegal. Right. But also, you just want to make sure that it's an environment where people are comfortable asking questions, and so you can help your company be successful.
Those note-taking AI things are all over the place. I don't advise using them, especially with the lawyer on the phone. Yeah, you'd ultimately have to be forced with trying to argue that they're privileged, and if there's not a lawyer or if there's not a privilege that would apply, it would be discoverable. So I just not a huge fan of those note-taker capabilities that pop up in the meetings.
Yeah, and then running the recording through AI is maybe a little better,
Yeah,
but it's still
right.
a whole third party.
Hey, everybody. Is this on? Yeah. Okay. My name is Daria Lucas. I'm with the firm's regulatory group, and I see this all the time in larger organizations or organizations that have multiple functions, and I've sort of just made it a regular practice because a lot of these functions, they don't know that, this is discoverable information. And so I make it a regular habit to, tell them, please turn off that transcription. I'm regulatory counsel. This is, a privileged conversation. If we want to keep it privileged, that should be turned off.